Have you ever stopped to think about all the pieces of information that make up your digital footprint, the data points that define you online and offline? From your name to your browsing habits, so much of who you are is captured by various systems every single day. But what truly counts as personal data when we talk about legal protections? Under the General Data Protection Regulation, or GDPR, personal data is broadly defined as any information relating to an identified or identifiable natural person. This means if a piece of information, either by itself or when combined with other data, can pinpoint an individual, it falls under GDPR's protective umbrella. The key concept here is identifiability. The core mechanism behind this broad definition is the idea that data becomes personal when it can lead back to a living individual. This includes direct identifiers like your name, address, email, and phone number. However, it also extends to indirect identifiers such as online presence data like IP addresses, cookie identifiers, and unique device identification numbers. Even seemingly anonymous data, if it can be combined with other information to re-identify someone, is considered personal data. The GDPR aims to protect individuals by casting a wide net, ensuring that various data types, from basic contact details to more complex digital footprints, are covered. For individuals, understanding this broad scope means recognizing the wide array of information about them that is protected. For organizations, it means conducting thorough data mapping to identify all types of personal data they collect and process. This often involves looking beyond obvious identifiers to include behavioral data, location data, employment history, and even biometric data. Imagine a fitness tracker that collects heart rate information. While anonymous on its own, when linked to your account, it becomes personal data. A particularly interesting aspect of GDPR is its treatment of pseudonymous and anonymized data. Pseudonymous data, like a customer ID number that replaces a name but can still be linked back to an individual through additional information, is still considered personal data and subject to GDPR rules. However, truly anonymized data, where the individual can no longer be identified by any means, falls outside the scope of the GDPR. This distinction is crucial because it highlights the emphasis on preventing re-identification, even when direct identifiers are removed. Special categories of personal data, such as health data, racial or ethnic origin, or religious beliefs, receive even higher levels of protection due to their sensitive nature. Ultimately, grasping the comprehensive nature of personal data under the GDPR is vital for both safeguarding individual privacy rights and ensuring organizational compliance. It ensures that your unique digital and physical attributes, no matter how seemingly small or indirect, are treated with the respect and protection they deserve in an increasingly data-driven world. This broad interpretation helps to create a more secure and trustworthy environment for everyone.